And that brings us back to Michelle White. Thank you, Ms. Baxter.
Morning, Judge. Drawing your attention to the 11 o'clock. Yes, sir.
I heard a lot about you, Mr.
Last week?
In the last week.
In the last week. I'll get with you. I'll get with you at another time on that. 11 o'clock hour with Dominic Jackson. That's with Mr. Eccles. He and I are going to agree to leave that on first Saturday as we're still in the process of doing discovery. And that can go to a June court date so we can check.
All right.
Thank you, sir. Yeah, Judge. Thank you.
Your Honor, this is State versus Michelle White, 14 CRS 56324. The defendant was indicted March 16th of 2015 for sex act with a student and indecent liberties with a student. If I might approach, I have filed a motion to modify the conditions of pretrial release in this case, and would like to be heard. I'll get the court a moment to review that. If I can update the court for purposes of the status of the case, Your Honor, when this case came out, there was, the case was based on, the defendant is obviously a teacher of the minor child at the high school. And as a result, it all started with some concerns expressed by people at the school, and then photos that were found, including one of the defendant kissing the victim at a school function on the mouth. As a result of the investigation, there were initially pretty voluminous discovery, including journals that were confiscated of the victims and the defendants that tended to document a intimate relationship and a growing intimate relationship. The victim at that time was quite traumatized, and her parents, in order, even after being told to leave the child alone and stay away, they discovered that there were secret electronic equipment provided to the child and accounts for which the child could continue to communicate. As a result of that, at the time of arrest, the child was removed from the area and in intensive treatment that was for her protection and her mental health needs. During the course, there were tons of computer equipment that were seized. We are still in the process of dumping those equipments, many of which there were passcodes, and it was not until sometime about in this past year that we were able to meet with the minor victim again to get passcodes and information in which to successfully open up the equipment. They have been dumped. I was informed that there were, in fact, the victim led us, the officer, to believe that there should be pictures of the two of them, the defendant and the victim together, and with including them in intimate relationships. I was informed that those pictures were found and set up an appointment with Detective Christie that had to be changed because of working with, I set it up jointly so that Ms. Baxton could be there to observe what we had at the same time, because I thought I understood they contained images that were not allowed to be duplicated. There were several opportunities that one or the other, because of scheduling, had to cancel and reschedule. Sometimes because of defense counsel, sometimes because of illness, sometimes because of the officer called away to a homicide. We, however, were able to meet this past Friday with the detective, and there were about 8 discs of material. And it was at that time that we had not been provided a summary of what those materials were. And it was at that time that we learned the officer had not yet had an opportunity to open and view all those discs. We were there for an hour and simply couldn't get through them. And so we left with the request of the officer to let him know he had permission for priority on this case to get through those items and provide us a summary of those, the voluminous discs that we have. That has not been provided yet. I have requested that he provide that by Monday. I've been notified that he is still working on it, and that his plan is to give us that summary by this coming Monday. Because of that, for purposes of this case, I will inform the court that the discovery is not yet complete, obviously, and is still in the untenable position of being in the first. The defendant has been out on bond the entire time. In review of the file, I'm not sure that the statutory orders of bond for child sex abuse cases were ever entered. We tried to correct for that at some point, but in the interim, the child she has felt safe. We talked with Ms. Baxton about during this pendency for the defendant to remain in Durham because the victim was not, but she is now, obviously she has aged as well and returning to Durham. Her parents are here and they're very concerned and would like to have opportunity to say something to you about their concerns of safety. I would ask the court, in speaking with them for purposes of bond, I would ask the court, at a minimum, I do believe that these images are supportive of additional charges. We have not brought those yet. It is my intent to know what we have, and because of the age of the case, to sit down and talk with Ms. Paxton. It is, the request at a minimum is so that this child does not have concerns of running into the defendant. She is looking at working this summer here in Durham. One of the areas that I would ask, one of the things I would ask the court to consider is, in addition to assuring that all these statutory provisions that are mandated for bond are put in place, and including for safety concerns, if we could include that the defendant be restricted, at least for the period of the summer, maybe review it come August or September, be restricted from the downtown and northwest of Durham County.
We live in the south.
From an area of north of Hillsborough Road of Durham County. And otherwise, because of the representations, I would ask that this remain on the first for the June 6th, and would entertain if the court would, because of the age, ask me to add it on the week of May 31st. I'm willing to consider that. It is the state's intention to move this quickly now and to shore up these issues of discovery.
So you're not asking for the court to revoke any terms of probation, other than geographic?
Your Honor, at this point, I have not had the opportunity to review and see what the digital images are. As I indicate, I do understand and believe that they may support additional charges. I will tell the court that I've informed Ms. Paxton that the victim has actually given a history of what would constitute B1 felonies. And it is my hope that we have, it is my belief that the digital images will support that. So I leave that in the court's discretion about where to go with that, but that's at least the minimum. The real concern is to assure the victim family obviously has concerns that no one else is affected in the course of this, but the major focus is the security and the safety of the victim. I have spoken with her. She's a young college age. When we discovered this, she was 17. And that is her request as well. She has been through a lot and is willing, she is available to the court and to the state, but no one needs to run into each other. It was such an extensive relationship, and that it was very detrimental to her. But other than as necessary in court, we need to ensure no communication with or interaction with the defendant, or direct or indirect. Her parents are here. I don't know if the court would allow them to be heard if necessary.
Sure, that's fine. I want to make sure I understood what the request was. Now, he said they live in the South.
Yes, sir.
South, I'm trying to see the reasonableness of the restriction.
Judge Hudson, we live in southwest Durham, and in the area Woodcroft, Hope Valley Farms. And what we were asking, if it would be possible, would be to see if we could kind of have a demarcation where we would not likely bump into each other. My daughter has been out of Durham now since late June 2014 and will be returning for the first time this summer. And she will be living and working in that part of town. And for her safety, given
Living and working in what part?
the southwestern part of town, sir. So we're just seeing if we could get a demarcation below which the defendant would not come and we would not bump into each other.
Right. And what you heard the DA asked for was that line being where?
We were thinking possibly about Hillsborough Road, sir.
Okay, I'm just trying to see, does that mean the defendant doesn't come below Hillsborough?
Yes, sir.
Above.
They were north of that, and we'll stay south of that. And
Okay, did you want to say something else?
I think Ms. Kenny has done a very nice job summarizing some of the things I intended to say. It's been a long and difficult journey. I would ask that the court not be fooled by the defendant's appearance. She is a practiced predator. She grooms, she separates, and she molests. She had multiple opportunities when working for the Durham public school system. She was investigated on 3 separate occasions. On the first occasion in November of 2012, the victim was 15 years old. Despite all the warnings, her predatory behavior continued. In April of 2014, there was irrefutable photographic evidence provided, and at that point in time, her tenure with the Durham school system ended. We had a note sent out from our attorney asking that she not contact my daughter, yet her predatory behavior continued. Over the course of time, we discovered a number of notes. On them were written the term "no matter what," implying the defendant's intention to continue to pursue this relationship. Unfortunately, it got worse than that. We intercepted some electronic communications where the defendant indicated that she had gotten a tattoo on her back representing the victim, and there were a number of very salacious emails or correspondence that we intercepted showing that this was elevating. We had done everything we could, and we, at that point in time, began working in earnest with the police department. We had to get my daughter, physically away and in some intensive therapy, and we did that in late June, and then in early July, the defendant was arrested and charged with 2 felonies. Since that period of time, my daughter has been working on healing, and we've had her out of town. This required great sacrifices on behalf of my family. I had to live separate from my family for a year in order to ensure a fresh start for my daughter. I'm here today to speak on behalf of my daughter, but frankly, I have concern for any young persons that this individual may be able to encounter. She is a practiced predator. The main thing that's changed here is proximity. Prior to this time, we had some distance, and I'm asking the assistance of the court to assist so that we don't run into something that none of us wants to happen, which is for this victim, for this predator to get back a hold of the victim and cause additional problems of trauma. I thank you for your time, sir.
Yes, sir. All right.
Thank you.
Yes, Ms. Banks.
Your Honor, we're going to ask the court not to
I
modify.
understand his concern, Ms. Banks.
Yes, sir.
I also know that your client does not want to have contact with the alleged victim in this case. I presume?
Absolutely. And if I may continue, Your Honor, Ms. White has been out of custody on these charges since July of 2014, and not once has she bothered contact or have any contact with the accuser in this case. Ms. White even moved from where she originally lived to put the distance between them to be in compliance with the orders of pretrial release set in place by, I believe, Judge Marsh in District Court. And it's my recollection that it was readdressed regarding the statutory requirements for sex offenders in Superior Court, and she has been compliant with all of those. And as this court knows, the purpose of bond is to ensure her presence in court and to protect the victim, and she has not had any contact.
No contact, not even accidental contact.
And she has been taking
Accidental
every step to
contact,
do that, Your Honor.
it's hard not to have accidental contact. I understand. And you understand the DA has an arsenal that she's looking at, where she's going to bring more charges, maybe.
I understand that.
Okay. I don't know how to enforce a geographical divide.
And I will ask the court not to.
I need for you and your client to help me not have contact with the victim. So how can you do that?
She can continue to do what she has been doing, Your Honor, by not having contact with the victim. She's been out of custody on these charges for over a year, and there has been no contact. And there will be no contact.
Yeah.
Your Honor, if I might, on the court's question about enforcing the geographical divide.
Yeah, you understand the problem, ladies. You understand the problem.
Yes, sir, and, you know, the courts have always, and statutes allow for restrictions on comings and goings and areas to stay away from. In this case, for purposes of enforcing a geographical divide, I would recommend to the court some type of electronic monitoring, and that can be set up so that it sets up whatever geographical restriction so that it beeps and notifies. That is
Possible would be to see if we could
but if we can print off a copy of the the AOC form on the bond conditions and sex offenders and ensure that those are there, that include no contact with the victim, direct or indirect, or her family, not her place of residence, not her place of employment, her school, and not to be within, I would ask the court not to be within 1,000 feet of any of those places as a minimum. Would ask the court to consider the electronic monitoring with the geographical divide of not be within the area of south of Hillsborough Road, Durham, in Durham County.
Your Honor, if I may, I would ask the court not to impose electronic house arrest because that in and of itself will require additional finances that Ms. White does not have. She is currently unemployed. Her husband is the only source of income. And to require electronic monitoring for someone who has been compliant with conditions of pretrial release for over a year is unfair. She has not had any contact with this young lady, does not wish to have any contact with her, and she has been compliant in all respects to the conditions of pretrial release that she was previously placed under, and she will continue to do so. I do think it will be unfair to require some type of geographical divide on the off chance that she may or may not encounter this young lady. She has no intent of doing that. She lives far away enough from them, and they don't even go in the same areas that it would be unnecessary for the court to require anything additional than what she has already been doing, which is staying away from the accuser and her family and not having any contact with any of them. So I would ask the court to leave her pretrial release conditions the same.
I don't want to know her address, but what part of the county does she live?
North.
Your Honor, I would ask if that address is not part of the court file. She has an obligation to correct and update the court file, that be done.
Your Honor, she has an obligation to appear in court, and she has been doing that.
So Ms. Baxter, I also don't see any bond information. What is a bond then?
If I can have a moment, Your Honor.
I think I see it.
My notes show that November 14th, I guess that was probably district court, her bond included no contact with the victim, direct or indirect, and not leave North Carolina without court's permission.
That is correct.
I don't know if it's been reviewed. We did come back into Superior Court. And I'm not seeing my notes on that date, but was it Judge Hudson at that time, Ms. Baxter, you remember?
No, I believe it was Judge Robertson, if I'm correct.
And I went back to look for the bonding paper, did not see any notes as a result of that bond hearing. I have a $6,000 secured that she posted July the 2nd of 2014.
It's my understanding, Your Honor, according to my notes, September 9th of 2015 is when the bond forms was readdressed with the requirements that Ms. Kenny is referring to regarding the ALC form, specifically for sex offenders. And Ms. White has been compliant with that as well.
It's in the,
It's in the
It is there with the sex offender finding condition?
all right, Ms. Kenny. Ms. Kenny?
Yes, sir.
I just want you to see.
Thank you, Robert.
All right, anything else, Ms. Baxter?
No, Your Honor. Your Honor, looking at that form, I would tell the court that based on what Ms. Kenny is saying about concerns of the accused of wanting to work in that area, and that form specifically requires that that Ms. White not be anywhere where she knows that the young lady works. If she gets employment and we're informed of that, and that can be added as a condition of bond. But right now, I do not see the need to impose any type of geographical restriction.
Yeah, I think I agree with the defense, Ms. Kenny, but when you find out where she's going to work, I think you might want to make it a part of it.
I know the general area. If you can give me just a moment, and I would ask at minimum to include that you remain away from that area of commercial business. I have a moment. Your Honor, she is secured employment in the South.
We're not gonna put it all in the public, we just put it over here. When you come over here, have a clerk amend this.
Okay,
You don't have to tell me how old or what.
okay. Thank you, Your Honor.
Come over here.
Thank you, Your Honor. Ms. Baxton and I have that. Does the court have it? And with regards to CMS, I would propose the June 6th.
June 6th is fine, Your Honor.
Your Honor, just with regards to the court's inquiry and request from Mr. Lassiter, I spoke with Mr. Brown yesterday, and he is planning on being here for the 11:30 setting. Given that he's out of town, I can double check to see if he'll be here anymore, but it looks like we're close enough anyway. So that's what we're waiting on to address that. Thank you.
Your Honor, at the 10:30 hour.